Following on from my video about the multi-tool, which you will find linked in the description, many people ask whether or not it is a lawful excuse to forget that you have a blade or pointed article in your possession in a public place, which of course, as I explained, is an offence under section 139 of the Criminal Justice Act 1988. So this I'm going to briefly address in this video. So welcome back, I'm the Black Belt Barrister helping you to understand law. So this very issue about being forgetful was looked at by the Queen's Bench Division in 2003. It was an appeal against conviction for having a bladed article in a public place, contrary to the Act. A carpet layer was found in a supermarket in possession of a lock knife. As you probably know, most carpet layers will need some kind of knife with them to cut carpet as they are fitting it. In this case, his argument was that he'd used the knife to cut vinyl before putting it into his belt and then going into the supermarket and forgetting it was there. His argument was that there was a fundamental difference between forgetting that he had the knife in a public place as against forgetting it whilst he was at home in a private place. And in essence, since he said he was forgetful when he was at home and forgot that he put it in his belt whilst he was still at home, then went to a public place, there was a difference between forgetting that he had it in a public place. Ultimately, he said that this amounted to an argument as to a good reason because he'd forgotten that he had it with him in a public place. However, unfortunately for him, the court dismissed his appeal and said that his suggestion that forgetting about it whilst he was at home could not be accepted as a good reason. There was a contrast with a case from 1961, which was around the Prevention of Crime Act of 1953, that makes it an offence that a person has with him in any public place any offensive weapon. The distinction being that this meant knowingly had with him, and in that case a man was found to be driving a van which contained some pick handles. However, the case that followed was another case from 1988, where again on appeal it was held that having forgotten that a person was in possession of such an article did not end possession of that article, and thus merely forgetting about possession of the article was not enough to end the possession nor amount to a reasonable excuse. Accordingly, in the present case that I'm talking about, the court held that in some cases the issue of forgetfulness might be relevant to a defence of having a good reason for possession of the knife in a public place, but in the circumstances described here, the court was entitled to find that he had no good reason within the meaning of section 139, and accordingly the appeal was dismissed and the conviction upheld. So this just goes to reinforce the message, especially if you are in a line of work that uses a knife and you do have a good reason, forgetting that you have it in your possession is not going to amount to a good reason for the purposes of the Act, and you will still be found to be in possession in contrary to the legislation. So again, as I said, there are many more examples like this, so please do subscribe and like the video if you want more examples like this, and as always, thank you for watching.